Thanks a lot for the invitation. First of all, I'm very happy to be here. And as I heard from Thomas, there is some variance within the audience, and I guess that each part of the talk will be familiar to many of you, and just hope that I can say something new about how I bring these together. So just a short introduction. That I work, as Thomas said, in the ICR group, which is the individual and collective reasoning, so a logic group within the AI lab at the computer science department in the Luxembourg University. And I'm responsible for all the AI and law projects. I won't talk about all of them, only one, my favorite one. And I'm also a board member in the Benelux Association for AI. Before coming to Luxembourg, I worked in the London School of Economics and in Edinburgh, and the Budapest University of Technology, and also at the Department of Logic at Florida University, which is the same department where I got my PhD, but I also have background in law and also in communication, but that doesn't really matter at this point of my talk. So not surprisingly, my focus is computational legal theory and applied logics for AI, how to use the formalizations of legal concepts and structures for artificial intelligence. Okay, compared to that, actually, what I start to talk about will be machine ethics. I'm pretty sure that there are many of you here who are familiar with these, with the issues behind machine ethics. What I would like to start from as an intuition or as an urge, if we talk about machine ethics and how to make it sure that the autonomous intelligent agents obey our rules, is that, well, let's say that our ethics or our moral rules have to be formalized in some ways. Well, this is not widely or not completely accepted by everyone. There are people who say that there should be some other solution, like using machine learning or some kind of learning the norms themselves, so we don't have to formalize them and don't have to build them up. It is fine if the machine learns it. At this talk, I will talk about the way when these norms, or these, well, ethics at least, is somehow given, and we have to formalize because we have to be, it has to be applicable to the machine. The machine has to understand in some ways these rules. Okay, this sounds a task for deontic logic, which is very good because this is my my focus research topic. We often say actually that this is not just deontic logic, but deontic logic and normative systems, somehow covering the two traditions within the deontic logic as a wider or more broad concept, containing not only those logics which are coming from the modal logic tradition and representing the permission, the obligation, or prohibitions, but also those deontic logic concepts or structures in which we explicitly refer to the norms and build up normative systems, and we see how this normative system behaves. So, okay, this is fine because we know these disciplines, we know what we can do with them. So the task seems to be given. However, it is not really clear that what our ethics or our moral rules are when we say that obviously these autonomous intelligent agents should obey our moral rules. That, okay, what exactly those are? I'm pretty sure again that you all saw this picture many times, or some of these pictures many times. The robust moral machine experiment with its amazing number of decisions and input data shows that, well, it is very far from the case that we could talk about a globally valid set of rules, the global ethics. So when deciding about what our moral rules are as humanity, well, it is far from obvious how we can do that. Actually, it seems that there is no way to talk about such a thing, because there is no such thing as our moral rules, our ethics as the society or as humanity. I just put here one comparison. Actually, it seems that Luxembourg, where I work, and Hungary, which is my home country, are very similar, but as I'm getting older, I see it was a good decision to move to Luxembourg, because hopefully Luxembourg, they will spare me when they decide who should be hit by the car. Actually, it's not just the people, the lay people who cannot decide or don't agree about what the moral rules are. If we check that how the professionals, those ethicists applied ethicists who have this task to decide about what ethical or moral rules the AI should follow, AI as such, so the intelligent AI systems should follow. It seems, as it was put in this paper, that while there are some emerging values, no single ethical principle appears to be common to the entire corpus of documents. Well, it seems to be an issue given that we would like to, so if we accept that for being or having guiding nature, it really should be put what should be done in different cases, then it is very difficult to start from this point where we don't agree. I mean, as people or as ethicists, we don't agree about these rules. Okay, one should, or at least could say that we might restrict the scope instead of talking about globally valid values, which is, well, difficult enough, obviously, because of the cultural diversity and so on. But let's consider that a given autonomous intelligent system will operate in a definite environment. It will be restricted in some sense. So just let's consider that given AI tool and then ask that, okay, then who is we? So whose moral rules should be followed here? We might say that, well, whoever is affected, which sounds good, but the problem is that there are always multiple stakeholders. And this makes the case, again, very difficult because these multiple stakeholders can come with very different normative systems. But even if these normative systems, meaning their moral expectations, their ethical, the norms that they follow, or at least expect others to follow, but even if these normative systems are not so different, it can be the case that they just simply don't agree on a given issue, because very small differences can result in a disagreement. There is a paper and the project which is called the Gemini Advisor. I don't know whether you are familiar with Gemini. Gemini is this small figure here with Pinocchio in the Walt Disney version of Pinocchio. And his job is to provide moral advice in morally sensitive situations to Pinocchio. And these researchers decided to build up a system incorporating somehow the different normative systems of the stakeholders. And as we mentioned, there are always multiple stakeholders, and putting an argumentation reasoning engine within the system, which provides the advice with based on some argumentation to what to do in a morally sensitive situation. Their example is that the smart home feels that there is some smoke, and the question is that if it comes from marijuana, then the parents should be messaged that the teenager left home alone, and this is what they do, or the police, or actually the fire station, because the smoke means that it might be fire. So there are some expectations, not necessarily moral rules, but there are different normative systems within coming with the different stakeholders, and the argumentation-based reasoning engine will somehow provide the answer what to do or which one to choose. But as I said, it is rather a question of how. If we check how Maria Slavkovic, who is a machine ethicist, well, it's not a good word because she's a computer scientist, but she's working in machine ethics. She recently talks about this whole setup as always coming with the small box in the left side, that conflict resolution has to somehow come with the system, or that has to be the first step in the system before we can do the moral reasoning algorithm and provide the moral choice to the autonomous intelligence system or the system itself for itself. Okay, the question is still how to do that, how to decide that whose rules should be applied by these systems, because given that we have an argumentation engine, that's fine, but based on what it will provide the answer, which one should be applied in a given case. What I suggest here is showing a parallel, a very strong similarity with a situation which actually arises in law, and which, given that it arises in law, has been addressed for long in law, and actually a solution has been provided on how to do this job. Let's see. I guess Thomas mentioned before the talk to me that there are some lawyers among you, so for them it will be very obvious. I just hope that for the others I can explain it very easily. So these are two countries that you see here. France is on the left-hand side, and Hungary with a small house and the small guy on the right-hand side. And the story is that this guy is called Sándor Farkas, and he lived in his house in the countryside of Hungary, which is nice enough, but he wasn't satisfied absolutely with his own life. Therefore, at one day, he decided to move to France in the hope of a better life. Actually, he did find a better life there. He found a girlfriend, he fell in love, they moved in together and lived happily ever after. Even so, actually, at a point, he accommodated himself so well to the French system or the society that he chose the French citizenship over the Hungarian one. And unfortunately, as all the nice stories, this also came to an end when Sándor Farkas died. And the story continues because he had siblings in Hungary who were very interested in what happens to the house. They actually hoped to inherit this house. So they went to the local, just a minute, public notary. And usually the notary who has this probate issue to decide that what happens, the question that she has to answer is that who inherits the house. She checks the Hungarian law and then in the civil code, the inheritance law, and then she tells the answer and orders that this is, and that is what will happen. However, in this situation, she has also a question beforehand, before she could start to answer the substantial question about who inherits the house. And the question is that based on which law she should decide who inherits the house, the Hungarian one or the French one. I hope that the situation already shows the similarity to the machine ethics problem of moral disagreement when we have multiple stakeholders in the machine ethics system. Here we have also multiple factors coming with different normative systems. And the first question we have to answer in order to proceed is that which law should be applied at all. And then when we decide about that, we can check what the answer is, what to do, what is the action that should be done. So this is the so-called conflict of laws. This is a branch of law. So this is not just a description of a situation. This is how the branch of law is called, conflict of laws, which is part of the main part of private international law. People often use this as synonyms, these two categories. The conflict of laws as a legal branch concerns relation across different legal jurisdictions between natural persons, companies, corporations, and other legal entities. The point is that this international law is actually not even international law, it is just concerns international situations or legal situations in which different nationalities or different parties, different factors of different nationalities are involved. And what is important here, that when the public notary decides whether she should answer the who inherits the house question based on the Hungarian law or the French law, she doesn't do that according to some feelings. And the point is that she doesn't goes around the Hungarian law. If she answers that it should be the French law, then this answer comes from the Hungarian law. Okay, so first of all, she's a Hungarian public notary. She has to apply the Hungarian law. So she has no discretion in this sense of deciding that, well, this is such an interesting case, I think that I should use the Chinese law or something. Obviously, anything that she does comes from the Hungarian law itself. And the Hungarian law might say to her that in this case, you have to apply the French law. So again, it is not going around, but going through the Hungarian law and potentially going also through the French law. Okay, how this thing is happened. The background of such situations is that there are there is international circulation of goods and people in an increasing amount, and there is a mutual acknowledgement between the countries that each other's legal systems are equal. So we don't think, or even if we think in the international relations, this is an axiom that we don't consider that some of the countries' legal system would be higher or more important or more developed or whatever. They are considered being equal. And there are differences in the legal systems, even within the EU. As you could see, I used an internal issue, I mean, internal in the sense of bringing two EU countries. But if you consider that this situation, Sándor Farkas could have moved to the US, to New Zealand, to China, or to Thailand, or to North Korea, and then of course the legal system would be rather different than in such a situation. But also in this situation, there might be differences. Actually, there are important differences between the Hungarian law and the French law. Okay, this is what brings the conflict of laws. What is important here is that we do not even check, or the notary doesn't even check whether there are any conflicts. It would be a very tiresome work to do. But the fact that there is a situation in which more than one normative systems could be applied brings this situation of the need to decide which one should be applied. Okay. This type of conflict, which is not even conflict in the sense of we don't necessarily realize where the conflict is, we already decide given that there are two potential candidates, but the conflict is not something that arises in such a situation. There are many types of conflicts in law, but usually it comes within a normative system. So if you think about these principles coming from the Roman law, these all arrange situations in which we have two conflicting norms within a given normative system. Okay, this is different from what we have in the conflict of laws, because in the conflict of laws, we have two normative systems equal in the sense of not having any prior arrangement, which one should be applied. And that will require some different solution because these won't work. Here, what we see is that, of course, if we have a higher law, then it will override the lower one. If we have a newer law, then it will override the older one. Or if we have a more special one, then it has to be applied and not the one which is more general. But these kind of considerations can be applied only if I have some orders, have some preferences, have some features that I can use within a given normative system. Okay, I cannot use these priority standards if I have two absolutely distinct normative systems and not two norms conflicting within a normative system where I can rely on some features that are already given, and these features can be considered based on some priority standards. There are some orderings I can rely on. In the conflict of laws, this won't work because you might remember that there is this mutual acknowledgement between the countries that the legal systems, the different countries' legal systems, are equal in the sense of not having priority any of them over the other. Okay, then what kind of solution can we use if we cannot use such kind of priority standards that we use in the Roman law principles? In order to answer that, I would like to show you already the formal setup that I use here. In order to show that, let's consider that we have legal norms. This will be the lowest level. We will consider sets of legal norms and also sets of legal norms. I will show you examples. So for example, that in the event a media service provider provides both linear and on-demand services, it shall notify each of its media services or press products separately. It's nothing really important. This is a legal norm. This legal norm is contained by the Act on Media. This is a Hungarian act, which is the set of legal norms. Okay, this is the second level. As you can see, this is the Act Act on Media Services. And this act is a member of a bigger set, the set of the Hungarian law, which contains approximately 7,000 statutes. Okay, so this is the three levels that we consider here. The language and the semantics I use in order to represent what happens in this situation is based on the approach which is used also in the so-called input-output logic. I don't know how familiar you are with input-output logic. If very familiar, then it will be super easy to understand. But if you're not familiar at all, I just say a few sentences, and for this talk, it will be absolutely enough to follow. So this idea of David Mackinson and Leon van der Torre was to generalize the theory of conditional norms and not relying on modal logic anymore, in the sense of not using modal operator, but to have an abstract study of how conditional codes are if we consider them as sets of relations between Boolean formulas. It will be clear in a minute. The point is that the core mechanism is the so-called detachment. So as you can see in the upper sentence, the point is to take norms as conditional norms. Okay, so maybe it can be contested whether every norm is conditional. I would say how I see the law, every norm is conditional, even if it is not obvious from the linguistic structure. Anyway, it's not important now. In this situation, we consider every norm as a conditional norm. And this is the way they express how a norm looks like is a pair of Boolean formulas where A is the antecedent and X is the consequent. As you can see, if you are familiar with modal logic or deontic logic, you would expect some kind of operator saying that, yeah, what has to be done, there should be an O. But here in the so-called normative system approach, coming from the approach of Huygens and Acheron, there is no modal operator. This is just a pair of formula, and the understanding of that this is an obligation actually comes from the interpretation of how we consider what this pair of formulas mean. And if you wanna read it, please read it in your head as that given A, X is obligatory, or X should be done. X should be the case. Let's say so, okay, because this is a proposition, not an action. So given A is true, X should be the case. As I said, there is no trace of should. Somehow the system behaves in a way that we receive back what we receive from, for example, standard monadic deontic logic or dyadic deontic logic, actually rather dyadic deontic logic, given that we consider conditional norms here. The detachment, because that's the main point, that we have these conditional norms. We check what the judge does, checks, or also we as people following the law and doing what we have to, we check the reality, and if we see that, well, A is true, then what we have to do is X, so we can detach X. That's the point of applying the law. And the detachment as a core mechanism is happening with this out operator, which is very intuitive, I would say, that if we have that, if given A, X should be the case as an element, as a pair of Boolean formula, but as a conditional norm, is an element of a member of a set N, which is normative, let's say a set of norms, because the normative system will be the set of norms. Then X will be in the out of N A, meaning that we can detach X given A is true from the system N. Okay, I hope it's clear and much easier to understand than how difficult now I seem to explain it. So what we need is that this out NA will denote the output of, that's why it's input-output logic, that A is the input to the system and the output will be X, because the normative system is what the input gets through and gets the output of X. And in the normative system, we have this conditional norm that given A, X should be the case. When we get the output, though, it's not a conditional norm anymore. It's an unconditional obligation that X should be the case, given that we just detached it from the conditional norm. Okay, what does it bring to us? It brings us that we will consider, because I extended this language that has been developed by Mackinson and van der Torre and further developed by many. So this is a very fashionable style of logic, I would say, used for causal reasoning also, not just deontic reasoning or normative reasoning. In this language that we need here, we will need to consider domains, which will be set of statement of facts. So those formulas those propositions, formulas that we would put as conditions in the conditional norms. And the big A will, the capital A will denote such a domain containing different propositions or formulas representing situations, statements of facts. We have norms, conditional norms, just like in every situation in input-output logic. We have set of norms or sets of norms containing different conditional norms. These are finite sets. Sorry for it's not obvious from the notation, but these are finite sets. And we will have sets of norms with containing different sets of norms, given that we will consider whole national legal systems which contain different sets of norms, like the Act on Media, the Act on Taxation, the Act on Inheritance, well, which will be part of civil code, but anyway. Okay, so these are the levels, or this is the notation that we will use. And the output of A under N is the set of obligations that apply to a current situation. This is what I just tried to explain with detachment as a core mechanism in the previous slide. Okay, actually, there are different out operations in input-output logic with the different semantics and different syntax. We don't need to consider these differences now. The point is that this is a very flexible framework, actually, in which we can express the differences based on how we would like our normative system to behave or our normative reasoning to behave. But we don't go into that because now it is not important at all. This is the whole level of the formalism or depth that we have to keep in mind in order to understand what I'm talking about. Okay, so if we use these notations to the example that I just gave you, then you can see that the example coming what these service providers should do in the case that they have both linear and on-demand services is then given A, X should be the case, where A is a member of the set of the domain, which will be the media domain. And on the other hand side, you can see that this Act on the Media Services is a set of norms in which is indicated by the A, that this is the Media Act or the Act on Media Services. Again, it's a finite set, and in the set we find different conditional norms. And given that this is a domain which is regulated here with this act, in these conditions, or all the conditions will be elements of the set of the domain, that what kind of situations can arise in the media that the legislation concerns as something to be regulated. And we have Hungarian law as such, containing the Media Act, containing many other acts about the protection of the environment, or how to pay the price if you sell a car, and so on. So there are many different, as I said, for example, in the Hungarian law, around 7,000 statutes, and all of them are indicated with a given domain, and they contain, or there is a missing parenthesis, sorry for that. So they realize the Hungarian law as such, which is a set of sets of legal norms. Okay, what is the task of conflict of laws? Because this is where we come from. This is why we would like to use this formalization or this normative system approach to the deontic logic, the input-output logic based approach, semantics and language here, is a so-called indirect ruling or indirect settlement. The direct settlement in the inheritance case is to tell who inherits the house. The indirect settlement, though, doesn't tell this. It only tells us that based on which law the public notary should decide who inherits the house. So directly, it doesn't give the answer, but this is the way we can get the answer. Okay, this is a special type of rules within law, which is called collision rules. And these international collision rules or collision rules are different than the classical, normal, substantial legal norms. A substantial legal rule directly settles the case. Of course, there are many types of legal norms, but let's consider the normal or the usual one, which directly settles the case. We consider also that as a conditional norm. In the hypothesis or in the condition, it is put what is the situation in the case of which a person should be guided by the given legal norm, and the operative part sets or tells what to do. It indicates the obligation or the permission or the prohibition or rights and duties. Actually, my other focus is about competition right theory. So this is just a simplifying picture, of course, but let's consider that this is the basic structure of a substantial legal rule. Okay, how a conflict of laws rule looks like. This is so-called international collision rule. This indirectly settles the case. So in the case of the hypothesis, this is still a conditional norm, but in the hypothesis, we don't see a given condition, we see a domain, which is a whole set of different conditions, but this is a domain of cases or types of cases actually. And the operative part doesn't tell what to do, it tells which legal system should be applied. Okay, this is a comment what you find in the operative part of a collision rule to apply the appointed legal system. Let's see how it happens. The point is that the collision rule unequivocally assigns the legal rule, the legal system that is to be applied to a given group of statements of facts. Okay, so to a domain. This is the point. Let's see an example. It will be super clear, I hope. The section 36, this is what when Sándor Farkas died in France and the siblings started the probate action in her office, the public notary opened the book of conflict of laws, which is an act also, actually, an act on conflict of laws, or was in the Hungarian system, never mind. And then she found this rule. The legal relationship of inheritance shall be adjudged on the basis of the law, which was the personal law of the testator at the time of his death. Okay, so if you see what happens here, that the condition indicates the domain, the inheritance issues, the legal relationships in an inheritance case, and the substantive part tells, the operative part tells that in that case, if the public notary sees that this is okay, an inheritance issue, the questions within that should be adjudged on the basis of the law, which was the personal law of the testator at the time of his death. So it doesn't directly tell obviously to the public notary that apply the Hungarian law, apply the French law, apply the American law or something like that. Since we don't know, of course, what type of nationalities will arise in this situation, and the point is not to choose between the nationalities. The point is something different. This whole idea is coming from Carl from Savigny, and he said that we have to find the local seat of a legal situation, of a legal case, actually. Meaning that there will be one national legal system which has a stronger connection to the case than the others, and that should be applied. Of course, it's still up to some kind of judgment which one has the strongest connection, but actually the conflict of laws acts all over the world are much more similar than the substantial act. So even if not completely the same, it seems that lawyers all over the world tend to agree about which legal system has the strongest connection to a type of legal case. Okay, so how this act looks like from the formal point of view, this is still a set of conditional norms like any other act, but these norms are special, as I have been trying to establish this thing. These norms contain not a pair of formulas, but a pair of sets. The first one is, in the place of the condition, is a domain, a set of propositions or formulas describing statements of facts. And on the second place in this pair, we find a sets of norms, which is a given national legal system. The inheritance case should be adjudged based on what was the personal law of the testator when he died. Okay, not directly telling which nationality's legal system, but describing it based on some factor of the case. So this set of these special norms contains these special norms, identifying different domains and commanding to apply different, not necessarily different, but potentially different national legal systems, and saying that the given situation should be adjudged based on the law of that country. And this is the Act on Conflict of Laws, which is an element and a member of the Hungarian legal system. Since the Hungarian legal system contains, as I've said, I think 3 times already, contains the Act on Media, the Act on Taxation, and also the Act on Conflict of Laws. I should actually indicate that in the Hungarian legal system, the Act on Media is the Hungarian Act on Media, and the Act on Taxation is the Hungarian Act on Taxation, and also the Conflict of Laws Act is the Hungarian one, because we have all these things mostly similar ones, or, well, ideally the same categorization in other national legal systems. For example, in this situation, we also have the French Media Act, the French Tax Act, and also the French Conflict of Laws Act, telling to the French public notary, seeing an international case, which law she should apply. Okay, the mechanism of the conflict of law collision rules, which look like this way of having the domain and a national legal system, is because, as I said, they don't directly tell which national legal system. They somehow bring it based on the factors of the given case, is coming from that we consider the statement of fact, which is put in the condition of a conditional norm, is actually a conjunction of different propositions describing or formulas describing the situation. What makes those cases special, which evoke the conflict of laws, is that these descriptions, or this description, this set of conjuncts contains different conjuncts of different nationalities. For example, if we say that what Faiz is that Sándor Farkas was a Hungarian citizen, the Sai says that Sándor Farkas actually was a French citizen when he died, so he switched nationality. The I might say that the house which he left behind is situated in the Hungarian countryside, and so on. This is also a finite set. Sorry for not indicating it properly. Meanwhile, of course, in reality, so in theory, we could use an infinite conjunction to describe how a situation is. The law provides some kind of restriction on this and consider only some elements relevant. So in the statement of facts, we will find those factors and the description of those factors. So also this formula would be finite. But the point is that normally the nationalities don't even come into the picture, because we are in Luxembourg, we consider the Luxembourgish law. Of course, the people coming in are Luxembourgish. Actually, in Luxembourg is very far from obvious, given that the half of the country is foreigners. But anyway, and probably the contract was signed here in Luxembourg, and so on. So normally this doesn't even come up. But the point is that the conflict of laws applicability situation is special, because the conjuncts refer to different nationalities, and this what brings the whole question in, that which law should be applied, which nation's law should be applied. Okay, and what such a rule that you just show, the section 36 from the Act on the Conflict of Laws does, that provides a partial order on the set of these conjuncts. And actually what is more in partial order, maybe it's not even important. What is most important for us, that there is a maximal element, because the maximal element will tell us that which law should be applied. Okay, so as you might remember, the section 36 saying that the legal relationship of inheritance shall be adjudged on the basis of the law, which was the personal law of the testator at the time of his death. This is something we already know. How does it look like from the formal point of view? It looks like identifying the inheritance with the A as the domain. So that's the set of those statement of facts which are related to inheritance questions. And in the command, in the operator, the ordering part of the norm, we find the national legal system, but the national legal system still doesn't refer directly to a country, but it does so by indicating that which factor will give us the national legal system. Okay, it says that it will be given by phi. So actually, what I started to say as an example what phi and psi is wasn't proper, because what we will see, well, we will see at the end of the day whether it was proper or not. So anyway, according to the section 36, what should be the phi here, which was the personal law of the testator at the time of his death. So phi is the contract which describes the personal law of the testator of the time of his death, which was the French law. So this national legal system to be applied to this inheritance situation, in this case, is the French law. So this is fine. But as you might remember, in the French law, there is also a Conflict of Laws Act. So what happens to the public notary? The case stays with the public notary in the Hungarian countryside, so it doesn't go anywhere. She doesn't send it. It can happen in advance, but that's a different question. What we investigate here is the applicable law rules. And then we take it for granted that the case stays with the Hungarian public notary, but still it might be the case that she has to decide this case based on the French law or any other foreigner law, because this is what the section 36 tells to her, that this is what she should do. Okay, so the public testator, also the personal law of the testator, which is rather the citizenship in most of the cases, was the French law. So she takes the book of French law from the shelf. She opens it, but where she should open it? One might say that obviously at the inheritance part, but from the French point of view, this is still an international case. There is still an international element, or many international elements in the case, because, well, indeed, the guy who died was French, at least the citizenship of his was French when he died, but originally he was Hungarian. There are siblings who are Hungarians. Also the country, so the house about which this case should be decided is in Hungary. So it's still an international situation. So the public notary might open the book at the conflict of laws, the French conflict of laws. And what she would find actually is a very, very similar rule. The French law also commands to apply the personal law of the testator, except there is a small exception, and this will be important to us here, except if there is a real estate in the heritage, because in that case, what happens to the real estate should be adjudged based on the place of the real estate, which is, I'm pretty sure you all know, the Hungarian law. So, of course, what should happen here is that the public notary puts back the book of French law on the shelf and takes again the Hungarian law books, but it's still an international case, and so on. So it seems to be a very painful infinite regress, which is stopped, because this is something that the legislator thought of, and they say that if, in accordance with this law decree, this was the reference to the set of rules themselves, foreign law is applicable, the rules of the applicable foreign law directly settling the issue in question shall govern. Okay, what does this mean? That if she finds in section 36 that the personal law of the testator, which is the French law, then when she takes the book of French law from the shelf, she doesn't open it anymore with the conflict of rules, the French Act on Conflict of Rules. She opens it with the inheritance case, and then she decides according to that. How does this look like? It tells us that actually the first formalization wasn't precise enough. We can provide a more proper formalization, where the operative part of the norm is actually the difference between the set of the complete national law, which should be applied, and its conflict of laws that should be subtracted, and just take the substantial part of that national law. However, there is only one more actually, but there is one more twist in the story. It is always easier to decide a case for a lawyer based on her own law, because that's what she studied, that's what she has worked with, so that's what she knows the best. So in those situations where it seems to be, you know, close enough, because it's also almost undecidable, which one? The Act on Conflict of Laws, or Law Decree on Conflict of Laws was the category of the statute, told that if, however, the foreign law refers back to the Hungarian law in the issue concerned, with regard to this rule, the Hungarian law shall be applicable, which means that with regard to this rule tells that not the Hungarian conflict of laws again, but if you find in the foreigner conflict of laws that you should go back to the Hungarian one, not directly, but based on the place of the real estate in the heritage, then don't open again the Hungarian conflict of laws, because then it never stops, as we saw, but open the Hungarian inheritance law, and that's where the story ends. Okay, so it's still the substantial law in order not to have the infinite loop, but if it's possible, then you can go with the Hungarian one. If we check this rule, however, it's not obvious how to put as a norm itself. It seems that this exception tells us that, well, this cannot really be put properly within the structure that we have, so we need some kind of meta rule here. Well, actually, already the norms in the conflict of laws, these collision rules, these norms are meta norms compared to the substantial norms, because they tell us when or which one should be applied. But these principles telling us how to apply these meta norms are meta norms, because, well, this is what they do. They tell us that how to apply the meta norms themselves. Okay, so in order to do that in the formalism or in the input-output logic structure that I started to work with, we just have to define the new types of the output, which is absolutely based on the out operation as it is. So if you are interested in input-output logic, you will find 4 different types of out operations. So any of them can be used, because this is just these are just new types of output operations with outputs based on the out operation, which can be any output operation from the input-output logic. And actually, these definitions are pretty straightforward. So if you just have some time and look at it. Okay, so what does it give us? This is what I showed you is all about how the conflict of laws can be seen from a point of view with a structure, with formalism, which is based on this normative systems tradition, so not the modal logic tradition. But the point is that if we have a proper formal setup, not just describing, but actually realizing this mechanism, which is, this is what I have showed you, is very preliminary, obviously, then it would be able to have, sorry, I already used the word here, which is the abbreviation of algorithmic conflict resolution inspired by law, so ACRIL mechanism. The point is that the context that we have, that this is an inheritance case, already would go in there to the conflict resolution part. This is the, okay, I hope you can see my cursor. So this was where in the picture of Maria Slavkovic, this is the box of conflict resolution. These are the stakeholders having different normative systems. And what this solution would give is that the context doesn't only come here into the picture, it already comes here to the decision of which normative system should be applied. So this would be a very context-sensitive, context-adapted system, which tells us already that which normative system fits most the given context, and then applying that context again and many other aspects that should be considered when we have an autonomous intelligent agent reasoning about what should be done. Then this model reasoning algorithm would already use the most applicable, the most fitting normative system to applied. Okay, so of course, many questions are super open, so there is a lot to be done. I haven't said anything about the logic itself, so it might be the case that one of or the other of out operations is better than the others, or also if you just consider it on any formalism, any framework formalism, then really that what kind of logic is needed in order to properly describe what is happening here. What I showed you about how the Hungarian Conflict of Laws Act handles the solution of avoiding the infinite loop is just one solution. This, when a case somehow comes back to the normative system from which it started, it's called renvoi. But of course, there are other solutions, cutting, for example, letting the case taken 2 steps, but not 3, or some other solutions which again prevents that there is an infinite loop and that the case is always settled. So it is nice to investigate that what the solutions are and which one works the best from the computational point of view. And of course, there are many questions of how to implement such a mechanism into machine ethics. What I wanted to show today is only the parallel between the situation and what the essence of how it is done in law could bring into machine ethics, therefore into AI. Thanks a lot.